Hello and welcome to episode 23 of the Legal Scoop, our webinar series here at LOMAD, where we talk about recent wins by our attorneys or even our staff. I'm Brendan Shannon. I'm an attorney here at LOMAD, and I'm joined today by my colleague, Vicki Buehler. Say hello, Vicki.
Hello, thanks for having me.
Thank you for joining us. So my understanding, Vicki, is you're going to talk about a recent win you had involving a significant gap in treatment from the date of accident to when the claimant suddenly started treating again. Can you just tell us a little bit about it?
Yeah, so this was a pretty old case. It was a 25A case, which, as anyone who knows 25A knows, means they're old. The claimant had injured her neck. She had treated for a year after the injury. Then she had stopped treating, and she didn't treat at all until she suddenly picked up again in 2022. And that treatment led into a neck fusion in recent months. So we were certainly disputing that treatment and wanted to find out what on earth was going on there.
Right. Now, and my understanding is, without knowing the exact time period or, different range or whatever, it was over 30 years potentially from when she first started treating and when she suddenly had this neck fusion, right?
Yeah, there was a really significant gap in treatment, and that was a huge red flag for us, as was the change in the symptoms.
Yeah. So, I think you would agree, Vicki, that in these type of cases, that's obviously, like you said, going to raise a red flag when there's a significant gap like that of 30 plus years. 10 years might raise red flags. And in that situation, I think the first step, I don't know if you agree, would be to file a CF1B, to any treatment that's coming in, after that gap, and to raise the issue of, causally related treatment as well as possible new accident.
Yes, I absolutely agree. I mean, I think if there's any real gap, even if it's just a year or two, it's not going to hurt anything to file the CA.1Bs, raise a question of new accident, and move forward and take the claimant's testimony because you don't know what happened.
Yeah, and I think we're going to get into this with what happened in your case. It's important to then look into, the medicals both before and after the gap to see if there's any indication as to whether there's been, a new incident or even just something that sometimes, even though we're not doctors, something might look completely different from what was happening before the gap. That might, raise, again, a red flag as to whether the treatment that's suddenly happening after this gap is causally related.
Exactly. So in my case, the initial treatment in the first year was really just chiropractic care. And then when she started treating again in 2022, she was complaining of radicular symptoms and significantly worse neck pain, which, as I said, bled into a fusion after she treated for a couple of years. And that was certainly a massive red flag. And then when we went through the later medicals, actually shortly before the hearing, we had a medical report come in that said she had a bike accident in 2021, about 3 months before she started treating again. And her doctor actually attributed all of her symptoms to that accident. So clearly there was a really significant intervening accident. And luckily for us, the claimant actually worked with us on this because she wanted to put it under private insurance. And so at the hearing, we argued that clearly we shouldn't be liable for this. And she went off on a tangent about how she wanted her private insurance to pay for it.
That's amazing.
Which was great.
Yeah, I love that. And I think for anyone watching, like adjusters or anything like that, you're probably familiar with cases like this. And, one of the concerns is that, it could be found to be something could be found to be an exacerbation, even though there's been a gap in treatment. But one thing we often like to raise is the question of a new accident or a new incident. There's certain things that need to be proven to show or to demonstrate that an exacerbation happened. So that's always something that can be attacked because a lot of doctors don't properly document that type of thing. And then, like Vicki said, you also want to raise the issue of a new accident because sometimes someone has an intervening incident that results in completely new injuries, and typically that results in a review of the prior medicals and the subsequent medicals to see if there's any new injuries or like that. A lot of times, like an MRI, for example, will have findings and then have completely new findings that don't look progressive. So those are just some things you want to look at. And I think in a lot of times in those situations, you might want to get an IME. I don't know if an IME would necessarily be, the first option that you want to take in these type of cases, but a lot of times you'll have cases like this where the gap isn't as significant as 30 plus years, or there isn't really evidence, obvious evidence of a new accident or new incident. I think in that case, an IME could be helpful. um, but that's a great win, Vicky. I think that's really uh, like it's kind of the ideal situation where even the claimant kind of wants the result you want. And then the ultimate finding, I don't know if you said it. What was the ultimate finding by the judge?
The ultimate finding, we actually got the judge to state that any treatment after the date of her bike accident was not causally related, which I don't think the judges realize this yet, but effectively killed that case.
Right. Yeah.
So, that's another potential plus. If you have a significant intervening accident that really changes things up, you may even have a finding of no further causally related disability that effectively ends your case.
That is excellent. Well, thank you so much for coming on the Legal Scoop today, Vicky. I think that's been a really helpful case. For anyone watching this video series, if you've got a case like this, like Vicky said, it's really important to just immediately file CF1B and raise the issue of possible new accident or causally related treatment, and to try and develop the record on the issue. And it's, again, really important to look closely at the medicals like Vicky did, to see if there's any evidence of a new accident or just something that's fishy that raises questions that are worth litigating. So thank you for coming on today, Vicky. We'll be back next month with episode 24 of the Legal Scoop. If you like our webinar series, this is not the only one. We also have one with Melanie Daly, and Andrew Gould puts out pretty funny videos periodically. You can subscribe to our YouTube channel below. Thank you.
Thank you.